People versus Richard Johnson.
Nimish Ganatra, First Assistant Prosecuting Attorney on behalf of the people.
Erica Julian, appearing on behalf of Mr. Johnson and 22F10963FY.
And Kenneth Overwater, Assistant Public Defender on behalf of Mr. Johnson on the other matter.
Your Honor, I think there is one more matter.
Yes, I had 3 and 2 attorneys.
Yes,
So
I'd be the third. Mr. Johnson in 22FB 5200FY, Your Honor. That'd be the home invasion case.
That was Mr. Johnson, so special he gets 3. Anyway, not my business. All right. What are we doing on any of these?
Your Honor, for my case, which is the 22F10963FY, we are requesting the soonest available Zoom preliminary exam.
All right. And Mr. Overwater, what are we doing on that case?
I would be asking for the same thing, Your Honor.
Okay. Looks like we have a pattern. Ms. Kracher.
Well, I'm going to break the pattern, Your Honor. I'm sorry. I just got appointed yesterday, and I would ask for a adjournment of the probable cause conference until December 15th, if that works with the court.
All right. So on the 22F5 5200 case, probable cause conference in that case will be adjourned to December 15th, 2022, 9 a.m. Bond on that matter will continue. On the other matters, you wanted a preliminary examination as soon as possible. I can do the 29th if you guys would be ready.
No, I cannot represent that we will be ready on that date.
All right. Then the next date after the 29th would be December 6th.
That's fine for the defense, Your Honor. And I know that Mr. Johnson has asked me to address bond at an appropriate time.
Okay. So I'll set Mr. Overwater. That will work for you, sir.
Certainly.
All right. Preliminary examination will be set without objection December 6th, 2022, 9 a.m. as to bond. And that's going to be December 6th, that time before Judge Tabby.
Is this via Zoom?
Yes, it is.
Thank you, Your Honor. As the 22F10963FY, he's being held on a $50,000 cash surety bond due to failure to appear at a prior preliminary examination date in September. I met with Mr. Johnson, and he indicated that he is attending Dorsey Community College, actually studying cosmetology. He's learning how to do nails there, as well as that he had secured 2 part-time jobs, one for E.B. Brown as a driver, where he'll do his training in marsh plating for weekends, that he is active in his children's lives. He has them 3 days per week, and that he is not a flight risk, and he apologizes to the court for missing court in September.
Okay, just so council's aware, on the home invasion that is being adjourned to the 15th, he has a $10,000 cash surety bond on that one. On Mr. Overwater's case, the receipt and concealment of stolen property motor vehicle, he has a bond of, I thought it was 500, well, 5,000, 10% on that one. On this case, he started out, yes, attending all of his court hearings, and then just didn't appear. Why didn't he appear for, and it was for, I said it for an in-person preliminary examination. Why wasn't he here?
Mr. Johnson indicated to me that, and I know that he has these new cases, that he was hesitant or scared to appear, believing that maybe there had been some type of warrant issued or some other entanglement, which now it appears that they have been charged.
So how did he come back into custody? I'm taking it he didn't voluntarily turn himself in.
I don't believe so. Mr. Johnson, would you like to indicate to Judge Simpson how you returned to custody?
I got caught up in this home invasion case. Hop in the car with somebody.
So he picked up another case, and that's how you came back into custody.
Yes, sir.
Motion for bond reduction is denied.
Better,
Yes, go ahead.
I apologize. I just want to address the home invasion case. And,
Yes,
and
sir.
the reason for that, as you know, is that is the most recent case that he has. And I know Ms. Kracher is getting up to speed on it, but I want to point out a few things about Mr. Johnson as he presents to the court. He has 8 prior felony convictions. He's been to MDOC before. He had previously been supervised by MDOC when he was released from prison. The guidelines on the home invasion case are 84 to 140. On the GBH case that Ms. Julian was requesting, I score him at 19 to 38. And the last case that Mr. Overwater is representing him on, the RNC motor vehicle / fleeing and eluding third, 12 to 24. So all of these cases contemplate a prison sentence. The fact that he has 8 prior felonies, has been to prison before, and on the home invasion case, there was a young man returning home when the defendant and co-defendant were in the home, and they assaulted him when they were confronted by the victim, kicked him in the head while he was down on the ground, fled. It's a very provocative case. It's very disturbing to public safety. And I'd ask the court to just revisit that bond amount in the home invasion, given the nature of it being a person that was assaulted, a strictly innocent victim, a U of M student. They targeted that house knowing it was a football game Saturday. People would be drunk, not locking the doors. So they were preying on students under those circumstances. And I think under his prior record and the nature of this offense, that home invasion is a lot more serious than it reads on the charge, Your Honor. Thank you. I don't have anything else to add unless you have specific questions for me.
I do not. Ms. Kracher, is there anything you'd like to say on that before court of the bond?
Just briefly, Your Honor, it is true that he does have prior convictions, but the latest, and it's true that he went to prison. He has been out since 2020, if I'm not mistaken. And most of those charges, as I understand it, that my client indicates, were receiving and concealing and not really a crime of violence. There was also, I believe,
Before you go on, and I don't understand this because of something that I saw this morning regarding a bond denied. He was on bond at the time of this offense. Am I right?
I can't speak to that, Your Honor. I'm assuming so, but I can't speak to that.
Go ahead. Go ahead with your argument.
No, that's all, Your Honor. That's all I have to say.
Well, he certainly was, just so that we know, he would have been on bond because this occurred November of 2020. He's actually on bond and on bench warrant status because he hadn't appeared for his preliminary examination.
Your Honor, can I provide some context with the prior felony convictions? One of them is felon in possession of a firearm. The other one is CCW. Another one is a separate felon in possession of a firearm. Another one is attempted home invasion first degree. So I think that there's a troubling pattern here in the prior convictions that you have. The other ones are theft related. We understand what the home invasion involved. He was there to steal property, and he did. He and his co-defendant took Xbox and Nintendo Switches. When the police pulled over the car that they were found in, there was a gun in the trunk. I'm not saying that they used the gun during the home invasion, but again, it fits a pattern of what he's done in the past. It's very troubling, Your Honor. And you know I don't argue bond on every single case that comes up. It's the rare incident and the rare occasion where I want to bring it to the court's attention. But I think this one deserves a review by this court on the prior bond on that home invasion.
Ms. Kracher, anything else you want to argue?
At this point, Your Honor, the prosecutor makes a statement regarding that the gun was in the trunk. I don't think it was an easy reach. I don't even know if it was the defendant's gun. It wasn't his car that he was in, so I don't even know if the defendant knew the gun was there. He's not charged with CCW or any of that in the home invasion case, Your Honor.
Right, but in this case, he was on bond and bench warrant status on other cases when he picks up this case. So again, and I'll just say, I think it was an abuse of discretion not to deny bond to the defendant when he appeared for arraignment and given at least the allegations surrounding the home invasion in this case. So therefore, what the court is going to do is the court is going to change the defendant's bond. Given all of those circumstances, bond on that matter is denied.
So I
Thank
got
you.
a bond for that case.
Sorry, sir.
Do I have a bond for that case or not, ma'am?
No bond on that case. You were on bond at the time. Thank you.
Thank you,
Court
Your Honor.
calls the case, People of the State of Michigan versus